And welcome back. We have been exploring legal implications in nursing, and we're going to start out today by talking about informed consent. So, informed consent is the process of communication between a patient and a physician that results in the patient's authorization or agreement to undergo a specific medical intervention. And the reason that I'm sharing it with you all is because oftentimes the nurse actually goes in and does some teaching and helps the patient get ready to sign the informed consent. And so we need to know a little bit about it. So what are some of the elements of the informed consent? Well, the patient's diagnosis needs to be on that, and the nature and purpose of a proposed treatment or procedure. The risks and benefits, of course, of the proposed treatment or procedure need to be on the informed consent, because the patient really needs to understand what their risks might be in undergoing any type of procedure that can result in a bad outcome. Because as we all know, sometimes there are risks associated with getting surgeries or, let's say, going in for angioplasty, getting different procedures done. Anything really that's invasive puts you at risk for infection, right? So we know that we need to let them know what the risks are. We need to have alternative treatments sometimes listed on the informed consent, the risks and benefits of the alternative treatment or procedure, and the risks and benefits of not receiving or undergoing the treatment or procedure that is proposed. Okay? So we want to make sure that we understand not only the risks and benefits of getting the procedure, we want to understand what alternatives might be, the risks and benefits of the alternative, and what if the patient decides not to get the procedure? What are the risks if they decide to do nothing? Okay? So that's very important for the patient to really understand what's going on with their care. The patient needs to know that they have a right to refuse. And they have a right to refuse even after the procedure begins. And certainly we hope this never happens. But, you know, if you're ever in a situation where you observe that this does happen, please know that the patient does have a right to refuse even after the procedure begins. So who cannot provide informed consent for themselves, right? So children, clearly if a child is found without their adult, right, without their guardian injured, then we need to take care of them, and we're not going to be able to get consent before we do that. Some states do have laws that vary. Those that are mentally ill, those that are mentally retarded, people under the influence of alcohol and drugs, patients with dementia and Alzheimer's, people who have experienced a trauma, right? So if someone is found in hypovolemic shock, if they are hypoxic and they're not getting any oxygen, they've had an acute mental status change and they're no longer able to speak coherently for themselves, in these cases, consent is implied, right? So in these cases, if somebody needs medical treatment, the consent is implied, and we are going to go ahead and care for them. Well, can a patient file a lawsuit against a hospital or a physician after signing a consent? Let's think about this. Well, we went through all the risks and benefits. We told you the alternatives. We told you what would happen if you decided not to go forward with the treatment at all. And you signed a paper that says you understood can the patient still sue for something that we warned them about? Absolutely. We live in the land of the free and the home of the brave. And that means that we all have rights. And anybody can sue anywhere, anyone, anywhere, anytime, as long as they can get an attorney to take their case. So, just because somebody signs an informed consent does not mean there will not be a lawsuit. Okay, so that being said, there's something to consider in terms of nursing and the law. I will say this, getting the informed consent is definitely helpful, right? So it's going to be a lot more difficult to, defend a situation if there is no signed consent. Although we, of course, could still sue anybody anywhere because that's what we do here. All right, so let's talk a little bit about adolescence and HIPAA, right? So we all know that HIPAA is partially about privacy, right? Protecting patients' privacy. That's not really all that HIPAA is about, but it is a pretty big part of it. I think it's safe to say it's the part that we focus on the most in the healthcare setting, the privacy part of HIPAA. Adolescents have a right to confidentiality, okay? And so what we're saying is we're talking about minors. We're talking about individuals that are under the age of 18. And over the past several decades, adolescents have gained many opportunities to receive confidential health services. And there's a reason for this, and it's mostly because clinical and public policy agree that protection of confidentiality for adolescents has been based on the recognition that they wouldn't seek health care if they didn't know it could be kept private and from their parents. So we want them to seek out health care, and if they couldn't receive it confidentially, we found that they won't seek it. So what we've done is we've made access to care for the adolescent, and we've put some rules into play to help keep them safe by allowing them to confidentially reach out for health care related to sexual activity, pregnancy, HIV, other sexually transmitted diseases, substance abuse, and mental health. So, I think it's pretty clear here what some of the issues are in the adolescent that really require us to take a closer look at, would they be very underserved if they could not reach out with their own private, privacy being, observed and upheld for these types of care, right? So clearly, these things can have a lot of stigma attached to them, and teenagers, if they have parents who maybe aren't so open to talk about these things, the patients wouldn't reach out. So, parental rights, right? So as a personal representative, parents generally have access to their children's protected health information, right? So what we're saying here is that the kid that's under 18 can reach out confidentially and get these services done, okay? However, parents do have a right to their children's protected health information, okay? But in specific circumstances, parents may not be the personal representative of their minor child. So let's look at some of those. A minor is considered the individual who can exercise rights for consent under the rule in one of three circumstances. If the parent has agreed to let the minor have a relationship with the healthcare provider that the parent is not involved with, okay? So that's one. The parent says, you know what? Whatever the doctor talks about with my 15-year-old, I am washing my hands of. It's between the doctor and my kid, right? Treatment of a sexually transmitted disease under a state minor consent law. When a minor has requested and received court approval to have an abortion in a state where abortion is legal without parental consent or notification. Okay, so in each of the previous examples, the parent is not the personal representative of the minor and does not automatically have the right of access to health information specific to the situation, okay? Unless the minor requests that the parent act as the personal representative and have access. So again, if we look back, we can see a couple of instances where if one of these three circumstances is the case, then they're considered, the minor is considered an individual who can exercise their own rights for consent, okay? So, the privacy rule allows a healthcare provider or health plan not to treat a parent as a minor's personal representative given a reasonable belief that the parent has subjected or may subject the minor to domestic violence, abuse, or neglect, or that treating the parent as the personal representative could endanger the minor. All right, and you're going, what case would that be in? Okay, well, I mean, let's say that a very, very angry parent is calling the clinic and asking about information about their daughter, who maybe recently came in and wanted to know if the daughter had been treated for a sexually transmitted disease, or wanted to know whether or not the daughter had been given a pregnancy test, and made a comment that they were going to kill them, right? If I find out that my daughter is pregnant, I'm gonna kill her, right? Now, you know, some of us might consider that a figure of speech, but others might not. And there might be a history of abuse in the family. And so if the healthcare team believes that there is an actual risk to the minor's safety by allowing the information to be released, then the healthcare team has the right not to report the information, okay? Access to the protected health information would likely cause substantial harm to the minor or someone else. Maybe the mother has called a few times threatening the staff because they want information about the daughter. Now the father is calling, threatening the staff, wanting information about the daughter, and makes a comment about, you know, killing her boyfriend, right? So it's not even just the minor that could be at risk here. If the team believes that someone else might be at risk for abuse or harm, right, then information can be withheld, all right? So there you go. Every state has laws that allow minors to give their own consent for some kind of health care, right? An emergency room, general health, contraceptive, pregnancy-related, HIV or STD, substance abuse, and mental health care. Those are the big ones, right? But again, you know, state laws can vary from state to state. So every state also has some laws that allow minors to consent for care if they are emancipated, living apart from their parents, pregnant, are parents themselves, or are high school graduates. So those are some other exceptions. Many of these states have had these laws in place for several decades, And the HIPAA privacy rule kind of defers to them, right? So HIPAA is federal guideline, okay? And so where states might differ from the HIPAA rules, the state laws, they've been in place for several decades, and HIPAA privacy rule just kind of defers to the state law, okay? So if you want to sort it all out, then you kind of have to look at HIPAA very carefully, and then you have to look at your own state law. So what is emancipation? It is a 16 to 18-year-old willingly living separate and apart from their parents with the consent or acquiescence, the reluctant acceptance of the parents, okay? So that's emancipation. They must be managing their own financial affairs. Their income must be from a legal source, fair enough. The adolescent should be in school. Emancipation must be in the adolescent's best interest, okay? So that, of course, is going to be decided by a court. The law on emancipation does not require that they be in school, but the compulsory education laws do. And the judge usually wants to see that they're either in school or have already graduated or gotten a GED, okay? So those are kind of the usual ways that, you know, emancipation is identified as being, you know, legitimate. And of course, it's the courts that decide, and fortunately for us healthcare providers, those aren't the decisions that we have to make. Although we can be called as witnesses sometimes in these types of cases when we have been a care provider for the minor in question. So I hope that this lecture on consent was helpful for you. I hoped that it helped you see how sometimes there can be some gray areas there, but we always have to remember as healthcare providers, when it comes to keeping our patients safe, whether they are over the 18 or under the age of 18, we do have the law on our side in terms of making a decision in a moment that we believe is necessary in order to keep a patient or another individual safe from harm. So I hope to see you again soon. Have a great day.